John Kamin, a partner out of our Woodland Hills location and the director of our editorial board, is here to present our annual legislative update. And as always, we have a couple of B&B attorneys here to introduce themselves. Mr. Sachs, would you like to start us off?
Yes, hello everybody. My name is Gary Sachs. I'm work in the Anaheim office. Our primary offices, boards that we go to are Anaheim, Santa Ana, Long Beach. And a fun fact about me is I get up very early in the morning, usually around 5 in the morning. My daughter has just started to really love plays and musicals, and she wants me to go to as many musicals as she can name, and I have found it very difficult to go to the late night musicals and fully enjoy them all the way through, but I have discovered the beauty of matinees. So now I can go to my musicals with my daughter and actually get through them. And if everybody wants to know, write me in 2 weeks and I'll tell you all about Moulin Rouge.
Nice. Okay, thank you, Gary. Thank you. Okay, Shannon, you're up.
Hi, I had to unmute myself. Hi, everybody. I'm Shannon Lang. I work out of the Fresno office and recently just started with the firm, but have been doing comp for many years. So look forward to working with you all and getting to know some of you better.
Thank you, Shannon.
Okay, well, with that, how about if we get started? I'll introduce myself. My name is John Kamin, and I'm a partner in Bradford and Barthel's Woodland Hills office. And I'm also the director of the firm's editorial board, as Tammy noted, which is a fancy way of saying that I run the firm's blog. And if you guys have any blog ideas, please let me know. We're always happy to hear from you, our clients. You guys come up with the best blog ideas. And sometimes when an adjuster has an unusual problem, and we help them find the answer, that can actually turn into a great blog idea, because we know if that senior adjuster ran into that problem, and there's probably another 100 adjusters out there who've also had the same problem. So that's kind of one thing we keep in mind when we're publishing our blogs is, hopefully it's going to be helpful to and help someone solve a problem out there. One fun fact about myself, when I was a newspaper reporter in Arizona, I used to cover the police beat. So I've covered prison breaks, explosions, forest fires, bank robberies, you name it, I've probably seen it. I've also interviewed FBI and ATF agents, and they're actually very nice and friendly and cordial people. And one tip, whenever you're working with people in government, always treat the secretaries and receptionists and clerks like royalty. They are the gatekeepers, and they can make your life much, much easier. Or if you anger them, they can make your life much, much harder. And so with that, let's get started on today's presentation, the legislative update. And what we're going to cover today is bills that were approved by the legislature and the governor, including SB 1127, presumptions, decision timeframes, penalties, and then AB 1751, that's an extension of the COVID presumptions, and AB 152, that's the COVID sick pay bill. And while we're doing that stuff, we'll cover future reform topics as well, as we anticipate some legislative reforms next year, as well as COVID sick leave strategies. Some other things we'll cover later on in the presentation are failed bills, or bills that were not approved. And the reason why we do that is you'll often see repeats, bills that didn't make it through in 2018, are reintroduced in 2019, 2020, and so on. Another one is rules updates. We'll cover QME evaluation dates and kind of what's going on with that, as well as telehealth. And then lastly, pandemic changes to the workers' comp industry. So let's get started with SB 1127. This was signed into law and it takes effect on January 1st, 2023. The key proponents of this are that it reduced the decision timeframe for first responder presumptions from 90 to 75 days. It also increased the penalty for unreasonable denials to $50,000. And it also has a increase for temporary total disability and the number of weeks that certain people can get. And so we'll cover all three of these in greater detail right here. First of all, the reduced decision deadline of 75 days, it applies to your standard first responder presumptions. So that includes hernia, heart, tuberculosis, pneumonia presumptions. And this reduced decision deadline does not apply to the COVID-19 presumptions because those already have their own reduced decision timeframes of 30 or 45 days. So basically, when you're thinking about this 75 days, it applies to all those first responder presumptions, but not the COVID ones, because those ones still are 30 or 45 days. Next, the increased penalty provision. This does apply to all those same presumptions that we talked about, as well as the COVID-19 presumptions. And Louis Laris, our appellate specialist, and myself, we're going over the labor code 5414.3 and the other sections in this bill. And we found that difference, that 5414.3 includes the COVID-19 presumptions on this $50,000 penalty for unreasonable denials, whereas the reduced decision deadline does not apply to the COVID-19 presumptions. And so that's a detail that is pretty easy to miss, so I want to point that out. And so the takeaway with that is that you want to make sure that your COVID-19 denials are backed by a good reason, such as non-industrial exposure, does not have a proper test, that kind of thing. And as far as the increased TTD provision, that's for first responders on cancer claims. So they can get up to 240 weeks for police and firefighters who have cancer claims. Now, one of the things you want to take away from SB 1127 is that it is indicative of legislative reforms to come. And different versions of this bill were axed in prior years. And so there's a sea change of major legislative reform in California about every 10 years. So what happened about 10 years ago? SB 863 took effect on January 1st, 2013. So it's been 10 years and it's probably due for another major legislative reform. And another source which has been indicating that is Tom Daly, who is the head of the Assembly Insurance Committee. He said about a year or two ago, while working on a bill just like SB 1127, that we will definitely see more workers' compensation reforms if Governor Newsom won the elections in 2021 and 2022. Well, he just did that. So next February, we can anticipate maybe seeing a major omnibus legislative reform bill. And so one of the things we might see in that is a reduced decision time frame for all claims. So maybe on your normal claim, you won't have a 90-day decision time frame anymore. Maybe next year's reform will try and reduce it to 75 or 60. Or maybe they'll increase penalties on all claims. These are topics that they've looked at, and as they were making the sausage, for example, as people were talking about SB 1127 and as it worked its way through the various committees. Other future reform topics could be the interpreter fee schedule. That was supposed to be implemented and it never was due to controversy. Every time they propose some new interpreter fee schedule rules, they get hundreds and hundreds of comments of people disagreeing about it. There's also been a push to increase the fee schedules every year. That has not happened, but you may see some lawmakers introduce a bill where they try and bump up the medical legal fee schedule every year. I hope that they don't, because it's already pretty expensive. Another target of bills over the years has been MPNs. Those will probably be targeted and are targeted every year. For example, a few years ago, there was that proposal to create a statewide MPN, which everyone gets into. In many people's opinion, that would undermine the entire point of having an MPN. But that being said, you may see some MPN reforms that are different from that proposed next year. Another area that's always under attack is apportionment to non-industrial causes. And so you may see some anti-apportionment measures. And another popular topic is anti-fraud. Every politician in the world loves coming off as tough on crime. And so you'll probably see some new anti-fraud measures. As to whether they'll be effective, that's debatable. Limiting CT claims was a popular topic we were hearing about 2 or 3 years ago, just before the pandemic. Another one is more stringent audit penalties. That's a topic we'll want to keep an eye on. Another proposal next year might be something on the voucher system, as there have been some fraud issues with the voucher system with certain unsavory providers. And another topic du jour that you're seeing in Orange County right now is increased protections for hotel workers. That's something that's been trendy. For example, some governments in Orange County are looking at requirements for hotel workers to wear something akin to a beeper, which they can press in case they're attacked or in case someone's hitting on them or doing something unsavory. And lastly, more presumptions. With one thing that the pandemic brought is the topic of presumptions, and not just California, all 50 states have been looking at more presumptions. And California did have many presumptions proposed as well in the 2022 legislative session. So those are all topics that we may see pop up next year in next year's omnibus reform bill. And if the reform bill doesn't come out next year, then 2024 is another possibility. So moving on, speaking of presumptions, AB 1751, this extends the COVID-19 presumptions sunset date to January 1st of 2024. So this bill extends the outbreak presumption and extends the first responder presumption, and as well as the executive order COVID-19 presumption. And if they didn't pass this bill, it would have expired on January 1st, 2023. Now, one thing we do have at Bradford and Barthel is we have a COVID response team. And so one thing we do is we help our clients consult on COVID claims, especially during the initial investigation period, but also during the later on in the claim as well, if you have for example, a long hauler COVID claim. So if you do ever have any questions or difficult COVID claims, feel free to ask us about them. We've done thousands of consults at this point on COVID AOE COE decisions, medical treatment disputes, stuff like that. PD is another thing that comes up. Not everyone knows how to rate PD on a COVID claim. And so one thing that we've anticipate this year from the COVID desk is we anticipate a holiday rush. So what that means is that there's an uptick in claims, usually in early January and maybe mid-December, as people tend to get together for Thanksgiving, for example. But then in December, people really get together that last week of December for the holidays, Christmas, New Year's. And then that first week of January, especially last year, for example, a lot of the TPAs got slammed with many, many COVID claims and many outbreaks. And so, for example, I can recall talking to one adjuster who I think had 100 COVID claims in January and February that she was sorting through and getting decisions out. Now, another problem that creates is the holiday rush coincides with confusion about COVID sick pay. And why is that? Well, this bill, AB 152, it extended that sick pay provision for all employees until the end of this year. And what I'm talking about is in February of 2022, Governor Newsom had signed SB 114 into law, and that was the 40 hours and 40 hours of COVID sick pay. And so what that meant is that under this one, it didn't matter how the person was exposed to COVID or got it. They could have gotten it from a sick relative, for example. So the first 40 hours they're entitled to, and then for the second 40 hours, they need to provide the employer with proof of a positive test. Now, this bill also allows people to get COVID sick pay if they're caring for a sick relative, such as a parent or a child or a spouse. And it also allowed COVID sick pay for employees getting vaccinated, or for people who are taking the relatives to get vaccinated as well. But please note that that expires on December 31st. So what happens after December 31st, especially as we are anticipating a COVID rush in 2023? Well, it's possible that in February of this year, Governor Newsom will do the same thing and sign that same bill into law and make it retroactive to January 1st. That's what they did in 2022, so it's reasonable to expect that they may do that again next year. Another thing that's also moving and changing all the time is whether the Cal-OSHA emergency temporary standards for COVID are going to expire. Right now, if they didn't take any action, they would expire on December 31st, 2022. And what I'm referring to is these Cal-OSHA sick pay mandates say that if there's a work-related exposure to COVID, the employer has to pay the employee as if they're still there. And long story short, they meet on December 15th, and I anticipate that they're probably going to extend the COVID temporary standards into 2023. It's technically, they have a meeting tomorrow, but I did not see this topic on their docket for tomorrow. So I'm pretty sure next month, on the 15th, we may see them rubber stamp the ETS, or emergency temporary standards, which would mean if there is a work-related exposure to COVID, the employer would have to pay the employee as if they're still there. Another thing you want to keep an eye on is if a local government, such as a county or a city, has their own COVID sick leave requirement. And so, long story short, our main takeaway with all this COVID sick pay talk, while it is confusing, our basic recommendation is that employers should pay COVID sick pay to employees who are legitimately out with COVID. And the reason why is that a lack of COVID sick pay often drives up claims frequency. It also, paying the COVID sick pay results in happier employees, and with a lot of these COVID claims, we're seeing a fast return to work for most COVID cases anyway. So people are just happy to get past the virus and get back to work. Now, let's also just take a look, play devil's advocate. Let's say all these COVID sick pay provisions expire on January 2023. So for example, no one does anything to extend the new COVID sick pay provisions. Employees still have options. They would have the state mandated 3 days of sick leave, and some counties have more sick leave than 3 days. They can exhaust sick time, PTO, or vacation. They can also request EDD. So if our lawmakers and regulators let all the COVID sick pay provisions expire, then these are the options for employees who do have COVID. And if you do have any questions about COVID sick leave, we understand it's very confusing. So just email the COVID response team and we'll be happy to take a look and help. So another bill that was approved this year focuses on fraud reporting. And it requires insurers to report suspected fraud within 60 days of it occurring. It also requires brokers and agents to report suspected fraud to the Fraud Division's Consumer Fraud Reporting Portal. It protects brokers and agents from civil liability for reporting fraud, and it also requires continuing education for insurance fraud. And by the way, that does apply to adjusters as well, and this bill does take effect. So next year, you probably will want to take some kind of CE on a fraud-related topic. And this leads me to a common reminder. So one thing I learned while going to a fraud conference at Disneyland years ago, where the district attorneys of Los Angeles County and also Orange County were, they really drove home the fact that most fraud cases, so basically when you're sending a fraud case to the DA, the thing they really want to see is an outright lie to get work comp benefits, or a really egregious material misrepresentation of fact to get workers' comp benefits. So you really want that kind of black and white lie in a deposition or to a doctor or all three. And the easier you make it for the DA or for the Department of Insurance investigators, the more likely it is that they're going to accept your fraud case. And so basically, the more lies you have, the greater the odds are that they're going to take a look at it. And one of the topics that they brought up is that I think it was the LA district attorney, he had complained that a lot of the fraud referrals were focusing on the amount of money spent on a claim. And really that's not on his radar. Really what he's more focused on is there a easily proven lie or material misrepresentation in the case? If so, then that's something that they're going to want to hear about. AB 1681 is another fraud bill that was signed into law this year. And this allows the insurance commissioner and their deputies to meet with insurers, employers, stakeholders to discuss fraud. And it also protects the people in those meetings as long as they themselves aren't committing fraud or as long as they aren't acting out of malice. And when I say protect, I mean protection from civil liability, from being sued by fraudsters. Now, SB 1002 focuses on MPNs and the addition of social workers and MPNs. And one of the reasons why lawmakers were interested in this is their reasoning was that this would help expedite mental health care to people who need it. And so, for example, I have some friends who work in various levels of California's education department, and their complaint is that while politicians brag about access to mental health care in our schools, there's still like a 6-month wait to get an actual appointment. And so I think lawmakers are looking at that in the work comp system, and by adding social workers, they figure maybe they can get someone a consult sooner than later. And if it is a really serious case or more comprehensive care is needed, or if a prescription is needed, that social worker can always refer that applicant to a psychologist or a psychiatrist. This one takes effect on January 1st, 2023. One side note, the social workers in these MPNs cannot comment on PD. So that's good. You really want someone with medical training commenting on PD. AB 2188 is another bill that was signed into law this year, and it bars employers from discriminating against employees who use marijuana away from the workplace. So what this bill means is that if someone is not intoxicated at work, but does test positive on a drug test for trace amounts of marijuana, the employer cannot discipline them for having a positive test with trace amounts. Now, there are some industries and trades that are exempt from this law: construction, builders, and this law takes effect on January 1st, 2023. Now, one of the criticisms we heard about this bill is that it might impact the intoxication defense. That being said, in my analysis of this bill, it doesn't impact the intoxication defense because the intoxication defense requires proof of intoxication at work. And so in your classic intoxication case, a drug test with a positive result was not enough to prevail on an intoxication defense. You also need witnesses, so other coworkers willing to testify that they saw the applicant that day and that they were slurring their words or acting strangely. Another piece of evidence you can use to help prevail on that type of defense is surveillance video. That's another helpful tool, and these days a lot of employers do have cameras everywhere. So if you do have that issue pop up and you think you do have an intoxication defense, you want the test, you want the surveillance video, and you also want witnesses. So keep that in mind if you do ever have that kind of situation pop up. Moving on, SB 1162 focuses on payroll reporting. Oh, and Tammy, is there a question?
There is. I wanted to tell you before you moved on to the next section. Will there be levels established with respect to THC levels to prove intoxication?
I don't think so, and I think it's a sliding scale. So as far as that particular bill, I don't recall there being specific levels in there. As far as the intoxication defense, though, I understand that's what your question is pointed to. Different people have different tolerances. So I think that may be why you may not have specific levels. And actually, someone had previously asked if there's specific levels, THC levels for DUI, for example. And I remember looking that up, and I don't think there are. So if they don't have it for DUIs, I don't think they're going to have it for the intoxication defense, unfortunately. And the reason why I say unfortunately is I get your point. It would be good to have a black and white number that you could refer to. And I hope that answered your question. And if you have more questions on that topic, feel free to put it in the questions bar or email us afterwards. We're always happy to help you out with affirmative defenses. And so moving on to SB 1162. This was an interesting bill. It's not comp so much as it is something more for HR and payroll. But it is notable. And so to understand this bill, we have to look at what existing law already requires employers to do before this bill came around. So employers with 100 or more employees have to report pay data to the Civil Rights Department. They also have to disclose pay scale to job applicants when they make a reasonable request for the pay scale for the job that they're applying for. Now, this new law requires employers with 100 plus employees to report to that same department job categories, pay data for each category, median, mean, hourly rate for each combination of race, ethnicity, and sex within each job category. And also, these employers with 100 or more employees also must keep their wage history during the period that the person is employed and up to 3 years afterwards. And frankly, that last bullet point could make things a little easier for us on the workers' compensation side, as sometimes it can be difficult to find wage statements. So if everyone actually does follow that, maybe it'll make things easier for us to get wage statements. This new law also requires employers with more than 15 employees to disclose pay scales and job postings. Or if an employee asks what the pay scale is for a particular job, they have to tell them. Now, if employers ignore this, for example, they have to report this by May 10th of next year. And if they do ignore it, then there can be fines and penalties of up to $100 per employee, and it doubles if there is repeated failures of that. And so the whole point of this bill is that it's aimed at identifying the outliers. In other words, classes of people that are paid less than others. And so the state is looking at monitoring this, and they're probably going to use this data. You know, I'm thinking that they're going to analyze this data over the long term and then base future legislative ideas on that data. Another notable is that aggrieved employees can file a complaint with the labor commissioner or in superior court in situations where they've asked about how much the pay is for a particular position and the employer ignores them. So there is the potential for civil liability under this bill. And this bill does take effect on January 1st of 2023. If you need more information about that, Brittany Roth-Kuschel from our Los Angeles office did an excellent blog on this about a month ago. Moving on to another topic, AB 1643 requires the state to create an advisory committee to write a report that evaluates the impact of heat on workers, businesses, and the economy. So they have to create the committee by July 1st of 2023, and they have to produce a report on that on January 1st, 2026. And the reason why that's important is future legislative ideas are probably going to come out of that report. Speaking of reports, AB 2848 was also signed into law this year, and it requires the DWC to analyze utilization review and provision of medical care during the first 30 days of a claim. One of the things that this bill tweaked is it expands the fields of claims where they're going to take a look at that provision of medical care to a 4-year period from 2017 through 2021. Now, the DWC was supposed to hire an outside consultant to analyze that data under earlier legislation. And I presume that they didn't do it, so that's why this bill was passed. So under this bill, they do have to produce that report by July 1st of next year. And that could be another driver of future legislative change. Another bill that was signed into law this year is SB 216. And this requires all concrete, heating, air conditioning, HVAC, asbestos, and tree service contractors to carry workers' compensation insurance, even if they have no employees. And the reason why is that, as many of you know, quite a few contractors, when they're applying for their license, they say that they have no employees and don't need workers' comp insurance. But then if you look really closely, you'll see claims where their helpers are getting injured or their employees are getting injured, but they didn't disclose that when they applied for their license in their industry. Another thing that to note about this bill is that all of these particular professions do at some point in their work involve working at varying heights above the ground. So in other words, they're at increased risk of falling. And other states like New York, for example, New York has its own construction law where they actually permit employees to file a negligence suit outside of the workers' comp system. Now, that's not the case in California, but basically in California, they passed this bill because they do want those contractors to have workers' compensation coverage. And that would simplify a great number of cases, and it would reduce the up-the-ladder liability situations that you see where applicants' attorneys are citing Labor Code 2750.5, I believe. That's the one that says that the hiring party who hires an unlicensed contractor can have workers' compensation liability for those helpers in some situations. Now, some bills that were not signed into law this year, but were proposed, is AB 334. This one would have expanded the presumption that skin cancer is industrial. So the existing presumption that already exists right now is a presumption for lifeguards. It's a skin cancer presumption. This bill would have expanded the skin cancer presumption to fish and wildlife and also parks and rec, but it was not signed in. It was not signed into law because Governor Newsom had vetoed it. Another vetoed bill, so in other words, it was approved by both chambers, went to the governor's desk and was shot down, was a expansion of the PTSD presumption that PTSD is industrial. So the existing presumption applies to most firefighters and peace officers. It would have expanded the presumption to more classes of firefighters and also security officers for state and federal departments. And some other failed bills that did not make their way into today's presentation include a proposal to drastically reduce decision timeframes. That was killed early in the legislative session. Another proposal was aimed at staffing agencies, and it looked to require staffing agency workers. So those basically staffing agency employees would have to be listed on the employer who controls the work site. That employer who's using staffing agency employees would have to list them on their workers' compensation policy as well. In other words, higher premiums for companies that use staffing agency employees. And so if I explain that poorly, here's an example to help kind of clarify that. For example, if Bradford and Barthel hired some temps to move our old paper files from point A to point B, we would have to list them on their policy under that proposal. Fortunately, that proposal was not signed into law, but it is something we may want to keep an eye on next year in case that is proposed as part of a future bill or reform. And then another one that caught people's eyes was a sweeping presumption that would have made a great number of hospital employees' conditions presumed compensable. Even a back injury would be presumed compensable. That proposal was also killed earlier in the legislative session. So fortunately, that one did not make it through either, but we may see that next year. Now let's move on to something that I've noticed that a lot of QMEs may not have realized, and also a lot of people throughout the workers' compensation system seem to have forgotten about. And that is scheduling with QMEs. So I wanted to go over our P's and Q's with QMEs. Now, before the pandemic, per this reg 46.2, the party with the right to schedule a QME evaluation had to schedule the initial evaluation within 60 days of the day that they make that call or send out an email to the QME's office. Now, that party with the right to schedule could waive the 60-day provision, and they could schedule that initial evaluation within 90 days. So if the doctor told them, I can't do it in the next 2 months, but I can do it in that 3rd month out, the party with the right to schedule could choose that. When the pandemic happened, the DWC bumped these up by 30 days. So your initial eval now had to be within 90 days, and the party with the right to schedule could waive and schedule within 120 days. And so guess what? Those extensions all expired on January 1st of 2022. And the reason why I bring that up is many QMEs don't realize that, many workers' compensation practitioners don't realize that, and it's something that's easy to overlook. We caught it in early 2022, but that being said, I actually have to go look it up and make sure that that's still the law. And the reason why is that there's been a twist, and that is that the DIR is currently looking at going back to the 90 and 120 days. They actually had a hearing yesterday on that. And so we'll keep an eye on the comments. They'll publish the comments in about a week or two. And the DWC, with that proposal, they can either go back to the drawing board and change their proposal, or they can submit it to the Office of Administrative Law. I presume that they're leaning towards submitting it to the OAL, or the Office of Administrative Law, for approval. But that being said, if a bunch of the comments that were submitted yesterday are negative, or point out some problems with this particular proposal, then they may just take it back to the drawing board. Another interesting question we've seen is, what changes to the workers' compensation world have we seen that could influence upcoming legislation? So let's take a look at how the pandemic impacted workers' comp. One of the big provisions was that employers got unprecedented access to health information. So who would have ever thought that the state would mandate all employers know how many employees tested for a particular virus? Before 2020, that would have been unthinkable. People would have been screaming about privacy rights, et cetera. But Cal OSHA actually mandated this with the vaccine rules and regs. And lawmakers at one point wanted employers to know as well, with SB 1159 and those COVID-19 presumptions. So that's one way that the world of workers' comp has changed and employment law has changed, is employers now do have access to certain limited medical information. Another culture change is that employers are now eager to send that sick employee home and pay them. Before the pandemic, you would have a lot of people who might have a cold or a flu and just go work through it. At court, we would see people come to court sick and say, stay away from me, I don't want to get you sick, when they shouldn't be at court at all. And then they would proceed to get everyone at court sick. So now post-pandemic, no one wants sick employees infecting their coworkers. And also many employees don't like, or many supervisors don't want to be the bad guy who made a sick person work through it. And then there's also peer pressure. Nobody wants to be near the coughing coworker, right? So that's been another change, is that now employers are sending more sick employees home, and they're happy to pay them their sick time and get them back on their feet and get them back to work to reduce industrial exposure at work. Remote work is another topic that we've seen pop up, and that's going to impact the comp world. As far as the pros, you have happier employees, less overhead for the employers, less commercial space being leased. But the big con for our industry is that you have more unwitnessed injuries, you have more sketchy CT claims or specific claims even. And because they aren't at the work site, there is no witnesses, there's no surveillance cameras, so disputing causation becomes even more difficult. And if you do have claims like that, our wonderful Michael Burns from our San Jose office has written about all kinds of remote injury claims, or people, and it's not always a remote injury. Sometimes you have people who do work at the employer's work site, but then they show up at midnight to get their keys or something like that. Michael has also written about those scenarios as well. So if you do have questions about remote injuries or injuries with weird timings or weird work sites, we do have stuff on our blog about that with many citations. Now, another big change that the pandemic has brought to the world of employment law and workers' comp is the See's Candy case. And the key words here are derivative injuries or derivative liability. And so what happened in the See's Candy case? Well, you had an employee at See's Candy allegedly get COVID from work, bring it home, give it to their spouse, and their spouse passes away from COVID. So this trickled all the way up to the Supreme Court with the question of, could the surviving spouse sue the employer in Superior Court for negligence? And the California Supreme Court, which is the highest court in California, said yes, that they can sue the employer in Superior Court for negligence. Now, the way they ruled on it, that issue popped up early on in the case. So it didn't happen late in the case. And so what happened is that the defendant, See's Candy, had filed a demurrer early on saying, wait a second, you have to stay within the realm of workers' comp, exclusive remedy. You can't even file that suit in Superior Court. So we have to wait and see how this case actually turns out, as that employee who's suing their employer still has to prove their case. So that'll be interesting to see. And I'm sure it will go up on appeal either way, regardless of whether they win or lose. Of course, the third possibility is that it settles. So if it settles, we may not see any new case law coming from the See's Candy case. Now, another weird change that the pandemic had on workers' comp is that the doctors became unpredictable. And what I mean is that when we were sending COVID claims to QMEs, we noticed that some liberal doctors were disputing industrial causation and really thought that it was just impossible, or maybe that COVID was very unlikely to have been caused by a person's work. And then conversely, we saw conservative doctors taking liberal approaches to industrial causation, and they want to say that everyone got COVID at work. And then the third category is we're seeing that some doctors, they don't know what to do at all, and they're guessing. And so what this does is it really puts the onus on us as defense attorneys and also claims adjusters to really get the strongest factual investigation at the outset of a COVID claim and really push the doctors with all that information. So that's really the best way to avoid these problems, and is to just have as many facts as possible. And if you have, if you have 50 facts showing that the COVID was likely non-industrial in nature, the doctor is far more likely going to swing your way as opposed to having 0 facts or 1 or 2. And that leads to change number 6, is strong factual investigations were normalized. So imagine before 2020, most employees would probably be resistant to a million questions about their personal life. What did you do last weekend? How many people were there? Did you go to any parties? Who went with you on your trip? These days, answering questions like that about non-industrial exposures to COVID are now par for the course. And employees don't get defensive about that when a claims adjuster calls and asks those 50 questions. And another change that the pandemic has had on our entire industry and on employers is that you now see personal space, plastic barricades, and masks. Trips to your local ER and hospitals still have mask requirements. Grocery stores still have plastic barriers, which some of the employees laugh at, but it does keep customers from invading their personal space, which is good because you can't trip over a customer if they are 3 feet away from you. And as the kids' cartoon Bluey would call it, nobody likes a space invader, or the Seinfeld close talker. And so by everyone keeping a little more space, I think it does reduce the risk a bit. And the WCIRB actually found that specific injuries did drop in proportion to CT claims during the pandemic. So that extra space does seem to have reduced orthopedic injuries. And then another change is presumptions galore. Everyone gets a presumption. So many states, such as New Jersey, Illinois, California, did create COVID-19 presumptions, which presume that the COVID is work-related. And then that reawakened interest in other presumptions, as noted earlier. For example, there is that presumption we were talking about earlier, where lumbar spine injuries for hospital workers could be presumed compensable. And so if there are presumptions in the future, the key thing you'll want to take a look at is, are they rebuttable? And do any future bills have language about how to rebut those presumptions? The alternative to a rebuttable presumption, which you really don't want, is a conclusive presumption, which you cannot rebut with other evidence. And so that actually leads me to another point about the COVID presumptions right now. If you do miss your decision deadline and you don't deny an outbreak claim, for example, within the first 45 days, you can still deny it, or you can still rebut it and fight it with evidence found after day 45. And so all the COVID presumptions in California do have provisions like that. So if you miss your decision time frame and you don't deny it, any new evidence can be used to rebut or fight those claims. Another change or impact that we've seen in workers' comp is that now unreliable tests are the norm. So the presumptions for the outbreak presumption and the first responder presumption still technically do require a PCR test, because those are far more reliable than the antigen or rapid test. So, and one of the problems with that is that rapid tests are far more likely to have false negatives during days 1 through 5 of a COVID-19 infection, meaning that person may not feel well, they take the test, they go to work and expose other coworkers, and then suddenly on day 5 or 6, now they're testing positive. So with that in mind, why are employers using rapid tests? Well, the reason why is that they're much, much faster. Nobody likes waiting 3 days for a PCR lab to send you back your result. In some industries, they don't have the time to wait 3 days. For example, nurses in the healthcare industry, they can't afford to wait 3 days due to nursing staffing shortages. So that is why you see some industries using antigen or rapid test. Another change which the WCIRB noted is that average weekly wages went up during 2020. And as I'm sure many of you noticed, underemployment was a popular topic in the news. Employers couldn't find employees, so they started paying their prized employees more and more. And as a result, I think that's impacted TD rates on more recent claims. So I think when the WCIRB in the future takes a look at 2020 through 2022, we're going to see higher indemnity spend on TD. Another area where you may see that creep into is in future legislation. Lawmakers may take a look at hiking the PD rates in 2023 or 2024. And the reason why is the current inflation problem, but also higher average weekly wages make that $290 a week of PD look a little smaller. So that being said, this week there is some good news. The inflation is shrinking a bit, and that's why you're seeing Wall Street jump. And Tammy, did we have any other questions that we should take a look at while we have a few minutes here at the end?
We do. Do you happen to know if an employer's numbers of employees or number of employees was over 100 in 2021, and then in 2022 the number was under 100, would that employer not submit the pay data for 2022?
So yes, you wouldn't have to do all that other. So yes, basically it applies to 2022 or that last year. And I'm just going back. So long story short, it's my understanding that if you had 99 or less in 2022, then you aren't required to comply with this requirement on the screen here.
Okay, great, thank you. And then Valentina noted that she called the medical unit this week and they still told her that it's 90 days, not 60.
Oh yes. Oh really? Interesting.
So just some information there. And unless you see some other questions there that you'd like to answer, I'm not seeing any others.
Okay. And let's see. No, I'm not seeing any. And I'm sorry if we didn't get to your question today. We will answer it after today's presentation. And thank you everybody for tuning in. And Tammy, I know that